Hello, everyone. This is Andy Rosenman. I'm a co-leader of the firm's US Employment Litigation and Counseling practice. And thank you for joining us today for this webinar. I'm joined today by my colleagues, Ruth Zadikany in Los Angeles, who's my fellow co-leader of the practice in the US, as well as our partner, Marcia Goodman, here in Chicago. And together, we will address the key issues and risks that employers are grappling with as they get back to business. We held a webinar for multinational employers in May, which discussed the employment benefits and mobility issues and risks at a global level. You can access that webinar through the firm's COVID-19 portal, which is called Responding to COVID-19, which is available through the Mayer Brown website or by searching covid19.mayerbrown.com. This U.S.-specific webinar today will drill down into a number of the details for employers specific to the U.S. The webinar is part of our firm's 1000 series, focusing on the top 10 issues that employers need to consider in the next 100 days. You can access the other webinars in this series over the coming weeks, and included in that series will be separate webinars on employment benefits issues, as well as global mobility and immigration, and country-specific webinars on employment issues from Brazil, France, Germany, Hong Kong, the United Kingdom, and others. All of those also can be found through the Mayer Brown's portal. Before we start the webinar today, just a few housekeeping slides. First, at the bottom of your screen, you will notice there are multiple application widgets that you can use. All of these widgets are movable, so feel free to move them around to make the most of your desktop space, and you can expand your slide area or maximize it to full screen by clicking on arrows in the top right corner. We're streaming this program through your computer, so there's not a dial-in number. For the best audio quality, please ensure your speakers or headset are turned on and the volume is up so you can hear us. Chrome or Firefox browsers are usually the best for purposes of the webinar. And if your slides freeze and you need to advance them, pressing F5 should help refresh the page. If you have additional questions or technical problems, please use the Help widget on the bottom of your screen. To submit your questions along the way, you can use the Q&A widget, and we will make every attempt to follow up with you either during the presentation or afterward. Finally, regarding CLE credit, we will be providing an alphanumeric code during the presentation towards the end. In order to receive CLE credit, participants must record that code on the virtual sign-in sheet that was emailed to you with login instructions for today's program. These forms are also available to download on the right-hand side of your screen under the resource list if you need them. So briefly, this slide identifies the 10 issues that we're going to try to cover over the next hour. There's a lot to cover, of course, with respect to employers and reopening. But we tried to hit the highlights of a lot of these issues today. And with that, I will turn it over to my partner, Ruth Zadikany in Los Angeles, who will start us off with our version of what I like to call PPE.
Thank you, Andy, and thank you, everyone, for attending our program today. I'm going to kick off our session by discussing the initial steps that employers should take in preparing to reopen or ramp up their operations. One of the most challenging aspects of reopening is the rapidly changing environment in which businesses are operating. In addition to adapting to a new business environment as a result of economic changes in the market, employers are also being charged with keeping up to date with safety guidance that various government agencies are putting out at the federal levels, including OSHA, the CDC, and the EEOC, as well as at the state and local levels. And those guidance documents are continuously changing without much notice. In light of this environment, one of the most important steps employers can take is to proactively plan their reopening or ramp-up plans and perform a comprehensive evaluation of their current and projected future business and operational needs. The plan should account for various contingencies. For example, if there is a significant uptick in COVID-19 cases in your jurisdiction and employers are either forced to by government directives or want to decrease their in-person operations again, employers might want to have those plans in place already so that they can roll them out right when it's necessary. The first step in creating a plan is assembling a cross-functional management team to deal with reopening and ramping up and ongoing COVID-19 response issues. In doing that, you'll want to select representatives of a number of key stakeholders in the business with different backgrounds, including human resources, information technology, legal, communications, and the facilities and operations team members. For businesses that are in numerous geographic locations, we have found that many employers have chosen to have multiple teams, a global or national team to create the bigger picture strategic plan, regional task forces, and then individual office task forces to address the specific operational issues at each location, particularly given the differing guidance among jurisdictions. It's important that the individuals on these task forces have sufficient authority or access to authority to act quickly and decisively, since things are changing pretty rapidly. Employers are also required to create a workplace health and safety plan, and we'll discuss some of the OSHA guidance in connection with that in a little bit. But, I mean, these plans should really address, infectious disease preparedness and response plans and address the different safety measures that are being enforced on the different federal and state and local levels. In creating such plans, some of the larger employers have retained external medical consultants to assist them in selecting the appropriate measures for their workplace, because measures that work in one workplace will not necessarily work in another. And we recommend having this plan in writing and updating it constantly. It's going to be a living and breathing document, just given the current environment. One of the key strategies for success is effective communication. Employers should assess their workplace culture and determine the best way to communicate with their workforce regarding upcoming plans, as well as any external vendors, consultants, or visitors to employer facilities. We recommend that communication should occur early on, even before any specific changes or measures are implemented, and it should be maintained regularly. During this time of uncertainty, we found that employees are feeling quite anxious and uneasy, and that any communication from an employer about upcoming plans, even if it's just to relay the plans, that plans are being prepared and the type of issues that are being considered are found to be helpful. We've seen a number of employers prepare surveys for employees to fill out regarding their thoughts and concerns about reopening so that the cross-functional team can address them. Employers should also put plans in place for training employees regarding new protocols, which is important both in facilitating compliance and just making employees feel good about how things are being handled. During the planning phase, employers should perform a comprehensive review of company policies to assess whether existing policies need to be amended or updated, or new policies need to be instituted, even temporarily, just to address the specific situations that arise with respect to the current pandemic. For example, many employers may want to issue revised travel policies, articulating their positions regarding work travel and personal travel, because, for example, current CDC guidance says that employees who travel internationally should quarantine for 14 days. So that's an issue that employers need to contend with. Employers may also want to review their expense reimbursement policies, particularly in jurisdictions such as California and Illinois, which have expense reimbursement laws with respect to work-related expenses. Teleworking policies are another type of policy that many employers did not have in place before the pandemic, but that they might want to put into place. And importantly, in returning to work, employers should consider the 5 W's in creating their return to work protocol. Who returns to work, when they return to work, where they return to work, why these employees, and what they are returning to. In putting together this protocol, employers should assess their short-term and long-term business needs and determine who they want to return first. And there are 2 aspects of this process. One is that employers should consider employees who were furloughed or laid off, so whether they want to rehire employees or recall them from furlough. And another issue is whether they want to then have certain employees return to the physical workplace. In line with many of the state guidelines, many employers are taking the return to work process slowly by dipping their feet in the water a little bit, seeing how things go, and then going from there. But in making decisions, employers should have a documented, legitimate business justification for the decisions they're making. So you don't want to just do it based on sort of your instinct. You want to have a documented reason for why you've chosen this employee instead of maybe a different one, and then also conduct a disparate impact analysis to ensure that there's no unintended consequence of the decisions that are being made that demonstrate a preference for one type of group over another. With respect to laid-off employees, even if employers are allowing those employees to retain seniority when they're rehired, you do want to keep in mind that you want to make sure you have your onboarding documents in order. So consider whether you want to have these employees re-sign NDAs so that there's no argument later on down the line that the NDA that they previously signed isn't in effect anymore, and consider things like that. In addition, employers should keep in mind that certain jurisdictions have passed new laws impacting the return to work process. For example, Los Angeles City and Los Angeles County have each passed right of recall ordinances that relate to employers in certain industries, requiring the employers to first offer their positions back to employees who were laid off under certain circumstances. In line with those ordinances, Andy is going to address the various government directives that businesses must contend with.
Thanks, Ruth. You know, it's quite a challenge for employers because, especially those of you who do business multi-state, you have all these different changing and evolving directives to deal with. You know, for example, here in Chicago, there are different requirements that the city imposes as compared to the state, because cities in Illinois that have 25,000 or more people are home rule cities, and they can impose stricter requirements than the governor of Illinois sets for the state. A good example of this situation, I think, is in New York, and the New York Forward program, similar to what Governor Pritzker uses as Restore Illinois here in the state of Illinois. New York is in different phases depending where you're at. New York City is obviously just in phase one, rather, as of earlier this week. The rest of the state is phase two, but the state has issued very detailed guidelines which any employer that does business in New York needs to be aware of. And so we've included some of the links on this slide here. These guidelines apply even if your business was already deemed essential. So, you know, you may already be operating in New York, but you still can't take these guidelines for granted. One of the requirements is you have to provide a written safety plan. And the template written safety plan in New York is a 6-page document. Another interesting thing about the New York guidelines is that there are no waivers permitted for employers who claim that they can't fully comply. And that's included in one of the frequently asked questions on the New York website as well. What I find most interesting is that the state refers to these as guidelines. And in each section, they're industry specific and obviously geographic specific within the state. But the guidelines say they're not intended to replace any existing applicable local, state, and federal laws. And then they go on to include 2 categories in each industry: those guidelines that are mandatory and those that are recommended best practices, covering 5 different categories: physical distancing, protective equipment, hygiene and cleaning, communications, and screening. And so there's obviously some natural inconsistency between what's a guideline versus something that's the state describes as mandatory. And one of the mandatory requirements in New York now is for the employer to provide notification to state and local health departments if they're aware of an employee who has tested positive for COVID-19. There also are a series of screening requirements related to COVID-19 and mandatory documentation. So all of those things our employers should be careful to take note of, because plaintiffs' lawyers likely are going to be looking for ways in which there was noncompliance and then allege that those deficiencies are grounds for litigation. Los Angeles, as Ruth mentioned a moment ago, has separate protocols. The Pletcher case that I mentioned here at the bottom of the slide is an interesting case. It's a Title III case against a grocery store. So the grocery store obviously has employees of its own, and the Department of Health in Pennsylvania issued an order saying that all customers have to wear masks except those who have medical conditions, and they can enter the premises without documenting their medical condition. So the grocery store understandably is concerned about protecting its employees, but it's also obliged to follow this directive from the Department of Public Health, which really doesn't impose any sort of minimum standard on an employee. And so one of the stores said, well, it would be too easy for a customer just to make up a reason and then not wear a mask. And so it refused to allow anybody in without a mask. An asthmatic plaintiff entered the store without one and was denied the ability to shop there and told to leave, and has filed an ADA case. That just happened last week, so we'll see where it goes. But those are the types of challenges that employers face here. Let me talk briefly now about who decides whether an employer is complying with safety standards. We've already seen inconsistent decisions in that regard. The Smithfield Foods case, the first case I cited up here, is an important one for all employers to read. The court granted a motion to dismiss by Smithfield Foods. It was a public nuisance case, and the court in that case determined that OSHA is better positioned to assess whether an employer is complying with occupational safe and health standards. And that's what's known as the primary jurisdiction doctrine. The court went on to address the merits of the claim that there was an alleged public nuisance because Smithfield hadn't implemented various testing and safety procedures. And the court has used some helpful language for employers about how it's nearly impossible in this environment for an employer to fully protect against the potential transmission of COVID-19. So even though it was a meat packing and poultry processing type of case, it's an important one for employers to be aware of, and it's one of the first decisions in writing that deals with some of the standards and the ways in which employers may be able to fashion arguments to protect against these types of claims. The Massey case, pending here in Chicago, reached a different result. There's not a written decision. The case is ongoing, and the most recent testimony in support of the plaintiff's request for preliminary injunction just occurred yesterday. But there, the judge in Cook County declined to invoke the primary jurisdiction doctrine and said essentially that the plaintiffs weren't asking the court to make up any new safety regulations. What's interesting about that case is the plaintiffs alleged that they complained 3 or 4 times to OSHA and got no response, and that OSHA clearly is not capable of dealing with the tens of thousands of complaints that employees have submitted all over the country and just in recent times. So there are a number of challenges here and inconsistent decisions that have already been issued. The Palmer case against Amazon doesn't involve meatpacking, and it will be interesting to see how the judge in that case handles the issue. There too, the plaintiffs seek a preliminary injunction based on Amazon's alleged failure to comply with public health guidance. One interesting caveat about that case is one of the plaintiffs contracted COVID-19 at the workplace, brought it home, and a cousin with whom that plaintiff lived died 30 days later. That's obviously a concern of all employers, but how do you prevent it? It's nearly impossible. That family member isn't part of this case, but may well file a wrongful death case against Amazon, and that's obviously another risk that employers face. So the Fair Workweek Ordinance is just a new ordinance that employers need to consider as well. Some states have enacted this in cities, and it limits the amount of predictive scheduling that employers can use. Lastly, here we have a link to a resource that is helpful for those of you who do business in multiple jurisdictions to try to track developments because so much changes rapidly. This is from the National Council of State Legislatures and includes daily updates about new developments in all the states with respect to COVID-19. So again, I think it may be a useful resource for those of you who are located in many places. And with that, I'm going to pass it over to Marcia to deal with leaves of absence.
Thank you, Andy. So let me pick up basically where Andy left off. Now, we're going to first talk about federal leaves and then move over to talking about state and local leaves. And So the first leave law that came into effect was way back in March with the FFCRA, and that provided that employers with fewer than 500 employees would have to provide types of leave that we never heard of before to make sure that their employees who were affected by coronavirus would be taken care of. The first is the Emergency Family and Medical Leave Expansion Act, which many people have taken to calling expanded FMLA because it doesn't have a nice, easy to pronounce acronym. And then the Emergency Paid Sick Leave Act. And I'm going to say that even employers with more than 500 employees have been affected by these laws because, in a sense, they set a standard both for states and for a lot of employers who are looking at their own policies. So the Emergency Paid Sick Leave law provides pay for the first 2 weeks when an employee is unable to work, whether it's due to their own sickness, to taking care of someone else who's sick, to a quarantine requirement, or by either an order or recommended by a medical provider, or when child care is not available. And that obviously has a very wide set of coverage. And then the expanded FMLA provides 10 more weeks of coverage, but only for the circumstance where you're caring for your child whose school or place of care is closed or the child care provider is unavailable. Now, when we think about those coming into the next stage of COVID-19 management, if you will, there will be probably less need for the expanded FMLA because more child care providers are becoming available. And also there's a question, for instance, if it's in the summer, then how does that apply? But generally, if you're relying on child care, if the employee is relying on child care and that child care is unavailable, then the expanded FMLA could come into play, but it's worth looking at the details of the particular circumstance. And even though these laws were put in place in March, there were many employers with fewer than 500 employees who actually never had the requirement to apply these leaves because instead of having people continue to work, they were unable to continue the business actively at all, and they laid people off. And in that case, then the leaves were not provided. So now I'll go on to the broader types of leave. So for other employers, and including a number of those with less than 500 employees, both the federal FMLA and related state and local laws that provide for family leave, for paid sick leave, all have continued to apply during this time period. And in a number of locations, New York, California, for instance, there are new state and local laws that apply to all employers. And while the details of the laws vary a great deal from place to place, generally they are providing for about 2 weeks of sick pay for various coronavirus reasons, including quarantine and child care needs. There are a number of trackers out there that we have access to, you have access to. If you want information about your particular location, feel free to reach out to us and we can help with that, as well as interpreting those regulations. I wanted to spend a minute talking about some of the practical approaches that we've seen our clients use, because with this patchwork of laws, sometimes they don't actually serve the needs of the employers, especially in the essential business context. Many employers have had to come up with ideas of their own because their employees were affected, their ability to work was affected by either sickness, quarantine, the need for child care, relatives that were ill for various other reasons. And some of those employers have created special COVID-19 leaves, a combination of paid and unpaid, but that they would make available, usually using the 12-week period as a time that they would look at supporting their employees. And one of the reasons that employers have done this is that they still need their employees, and this is particularly true of essential businesses. So they can't afford to say, even if the law permits it, well, you can't come to work or you can't work at home, we don't need you. That's not a position that a lot of employers are in these days, even with the high unemployment rates. So I just throw those out so that some of you may get ideas that you haven't thought of before in this next stage when people are needing to come to the office and may have some of these coronavirus-related issues anyway. Then we encourage you to review your existing policies because it is the case that a lot of practical approaches have evolved and may not have been written down. And so those are things that we would want you to do. Let me turn it back to Ruth for implementing safety measures.
Thanks, Marcia. As Andy mentioned earlier, one of the major issues that many employers are contending with in reopening or ramping up their operations is how to reopen in a responsible way that keeps their workforce safe and minimizes potential liability, because lawsuits have already been filed and there will likely be more unless an immunity law is passed. There's no specific COVID-19 statute that really sets forth every requirement or the minimum requirements that every employer needs to follow. However, under the General Duty Clause of the Occupational Safety and Health Act, employers are required to provide employees with a workplace that is free from recognized hazards that are causing or are likely to cause death or serious physical harm. In the context of the current pandemic, this means that employers should take reasonable measures to prevent occupational exposure to COVID-19 in the workplace. I think there's an understanding that you can't prevent it entirely, just given the nature of the virus, but you need to take reasonable measures to prevent it. And there are 4 different categories of legal considerations that employers should be aware of. As I mentioned earlier, there's the CDC and OSHA, who have each issued guidance to provide businesses with information regarding potential safety measures they can implement. And states and local governments have also issued guidance or executive orders relating to workplace safety, in addition to which the EEOC has issued guidance, which Andy will discuss, relating to the interplay between these safety measures that we're talking about and the ADA. The CDC issued a guidance document called Interim Guidance for Businesses and Employers Responding to COVID-19, which provides general guidance to businesses in all industries regarding preventing workplace exposures to COVID-19 in non-healthcare settings. Importantly, the guidance is constantly being updated, so you really do need to check the CDC website and make sure that you're using the most up-to-date guidance. I believe the CDC initially posted the guidance in March, and it has since been updated as recently as May, I believe May 6th. OSHA also issued a guidance document called Guidance on Preparing Workplaces for COVID-19. Now, this guidance document was issued earlier on in the pandemic. I believe it was in March. And although it's not as up-to-date as the CDC guidelines and doesn't really address the community spread that has happened since the document was issued, it does provide a useful framework for understanding how OSHA expects employers to approach workplace safety and the steps that OSHA expects employers to take. OSHA is also issuing new and updated other documents. For example, on May 28th, OSHA issued COVID-19 guidance on social distancing at work, which employers should read. They've issued guidance for cleaning and disinfecting. And yesterday, OSHA posted an FAQ document regarding cloth face coverings on its website, which addresses the key differences between cloth face coverings, surgical masks, and respirators. It also clarifies that cloth face coverings are not considered personal protective equipment, or PPE, and that as a result, employers are not required to provide such coverings. I'm going to caveat that and say, but there could be state law requirements that do require you to provide face coverings if you're requiring employees to wear them. The FAQs go on to say that OSHA recommends that employers encourage workers to wear face coverings at work, consistent with CDC recommendations, but that face coverings are not a substitute for social distancing measures. The CDC and OSHA have also issued industry-specific guidance to address the specific work environments of various industries. For example, the CDC issued guidance for employers whose employees work in office buildings. The CDC and OSHA issued joint guidance with respect to meat and poultry processing facilities, and we have links to them in the PowerPoint here. In addition to the federal level guidance, there's also state and local guidance and executive orders for each specific jurisdiction, many of which impose restrictions. And Andy covered them, so I'm not going to recover it. But the important thing to know is, with the exception of certain things like social distancing, the guidance provided on the state and federal level is really a non-exhaustive list of practical safety measures that these agencies tell employers that they should consider implementing. So although you don't have to implement all of them, the failure to implement them may be used as evidence of not taking reasonable steps. So we've been advising employers to take as many of the specific precautions listed in these guidance documents as possible, even when they're not mandatory. Going on to how you put together a safety protocol, OSHA and the CDC recommend that employers perform an initial hazard assessment of the workplace to identify where and how workers might become exposed to COVID-19 at work. For example, this would entail identifying the work and common areas where employees are likely to have close contact within 6 feet of others, for example, at time clocks when they're signing in. It involves creating a communication plan, and we discussed some of this initially in this session. Once the hazards are identified and assessed, businesses are instructed to develop hazard controls to reduce potential transmission among workers. Worker infection prevention recommendations are based on a framework that OSHA refers to as the hierarchy of controls. And you'll see in the slide on the top right side, I've taken the OSHA hierarchy of controls and put it in here for you to see. The hierarchy of controls groups actions that employers can take based on their effectiveness in reducing or removing hazards from the workplace. And this is used generally to deal with hazards, and OSHA has stayed consistent and is using them with COVID-19 as well. The OSHA hierarchy of controls pyramid demonstrates that elimination of the hazard by physically removing it from the workplace is obviously the most efficient control. Unfortunately, given the nature of the virus, that's not really possible. And as a result, OSHA and the CDC have advised that during the COVID-19 pandemic, the most effective measures to prevent infection are engineering controls, which I'll discuss in more detail in a few minutes, and administrative control and use of personal protective equipment. Engineering controls involve isolating employees from work-related hazards. So these types of controls reduce exposure to hazards without relying on the worker behavior. So these include installing physical barriers, such as transparent shields, to separate employees from one another, rearranging or removing furniture in communal areas to facilitate social distancing, replacing high-touch communal items with single-use alternatives. So that means doing things like removing water coolers and replacing them with water bottles, replacing bulk snacks with, mini bags, things like that. Employers are also instructed to take steps to improve ventilation in the workplace, and the CDC really does provide a very long list of potential ways to do this, including things as simple as opening windows and then things like installing high-efficiency air filters. Administrative controls are the second step, or the second preferred method. So you really should put a preference on engineering control, and then you go to administrative controls, which are typically changes in work policies or procedures to reduce or minimize exposure to a hazard. These include implementing policies that prohibit sick employees from coming to work, encouraging employees who are in close contact with someone who is a confirmed case of COVID-19 to stay home, immediately separating sick employees from other employees. Your employees are also recommended to look at the workflow of their facility and make changes that are not necessarily physical changes to the work site, but other types of changes like, adding time clocks, staggering shifts so that employees are not arriving to work at the same time or taking breaks at the same time, designing shifts so that you have work cohorts where certain groups of employees all work together at certain times, and dividing up the week or the workday that way so that different cohorts of employees are not exposed to one another in the event that there is an exposure in the workplace. Obviously, employers should be implementing the recommended cleaning and disinfecting protocols, which the CDC has issued and which are available on their website. Andy will discuss in more detail a little bit later, but there's also the option of conducting daily in-person or virtual health checks. The CDC has really also put a lot of emphasis on signs and making sure that you have signs in the workplace, such as visual markers reminding employees to stand 6 feet apart on the floor, and signs that talk about hygiene and remind employees to wash their hands all the time. Employers should also make sure that they have all the necessary supplies, for example, disinfecting supplies, and if they're requiring employees to have certain PPE, the employer should provide it. Given that there have been shortages, I still can't get Clorox wipes anywhere. Employers should think about that before employees come back to the workplace. So the PPE goes hand in hand with the administrative controls. Employers should provide PPE to employees as appropriate based on the work site. And another area where OSHA has really emphasized, employers should emphasize employee training. And training should be easy to understand in the preferred language spoken or read by the employees. And it should discuss things like the signs and symptoms of COVID-19, social distancing, use of PPE, hand hygiene practices, identifying and minimizing potential transmission at work, home, and in the community, and the importance of staying home when sick. I think a lot of us often, think that this is obvious to everyone, but there are people who don't know it, and as an employer, you want to make sure that you've taken the steps to train the employees to do it. With that, I'm going to hand it over to Andy, who will discuss health screenings.
Thanks, Ruth. So there are three basic types of testing and health screening that employers are contemplating. Temperature testing is the first one on the slide, and that's the one that we're being asked about most commonly. None of these methods is perfect. Obviously, an asymptomatic employee can bring COVID-19 into the workplace no matter how many types of precautions an employer takes, and that's one of the challenges that employers face here. But there may be a perception among your workforce that implementing some form of testing is an example of the type of steps you're trying to take to reduce the risk of transmission. And so, that's something for employers to consider. While no method is perfect, might one of these methods help to, assuage the concerns that your workforce has about contracting the virus at work? The CDC and OSHA issued joint guidance in May for meatpacking and poultry processing facilities. And Ruth and I wrote about this in a fairly lengthy update that's linked at the end of our presentation. That guidance is good for all employers and important for all employers to review because its principles apply among a much broader workforce than just those who are involved in meatpacking and poultry processing. As part of that, the guidance provides that employers must ensure that screeners are provided with appropriate PPE, that they're trained to use temperature monitors, and that temperature monitors, account for variations like really hot or really cold weather that can impact the reliability of those types of tests. But there's no question that temperature testing is permitted as a result of the EEOC's technical assistance document that it issued in the wake of the WHO's declaration of COVID-19 as a pandemic back in March. So some employers have asked, should we use the CDC guidance of 100.4 degrees for our standard, or should we use something less? I've advised clients that you certainly, are in a safe place by using 100.4. But I've also seen a couple employers that have said we're going to use a standard of 100.0 just to play it safe. The issue of COVID-19 testing is still evolving. There are obviously there's lots of news coverage about the reliability of the tests and false positives and false negatives. The EEOC technical assistance document permits such testing, but it requires that the testing be accurate and reliable. And so as part of its technical assistance guidance, the EEOC says that employers should check CDC and FDA guidance on the types of tests that are considered safe and accurate. One employer asked us, what about using antibody testing? And that's not addressed in the EEOC guidance, but the FDA has weighed in on it, and the FDA currently says that because antibodies are part of the immune response to exposure and not the virus itself, antibody testing can't be used for diagnosis of infection, and based on the underlying scientific principles, the FDA does not expect that an antibody test can be shown to definitively diagnose or exclude COVID-19 infection. So at least at this juncture, we don't recommend antibody testing as something on which employers should rely. A related question is who ought to perform the testing? If your personnel are going to conduct the testing, there's obviously a greater risk that those employees may contract the virus and file workers' compensation claims. And Ruth will talk a bit later about some of the workers' compensation presumptions that exist. We think having a third party do it is preferable if possible, because you may be able to negotiate commercial terms, you may be able to get indemnification provisions as part of that process, and it helps reduce the risk for the employer. In addition to the temperature testing and other types of testing, health screening questionnaires are another option for employers. And the question there is, how, when, and where you'll do it. Some employers are using a poster at the workplace and asking employees to look at those questions. Do you have a sore throat, or have you had a fever in the last 24 hours? The common symptom questions, and just asking them to answer the questions on the spot. Others have implemented measures where the employee fills out an email before coming to the workplace to make clear that he or she doesn't have any of those kinds of symptoms. And some have implemented apps along those lines as well. It's the kind of thing that we also recommend for any visitors or customers to the workplace. And landlords and building owners may need to be part of that equation if you are a tenant in the building, of course. Some employers also asked us about liability waivers. In some states like Virginia, they're not even enforceable. We're not aware of a court that has yet been called upon to address it. And some states permit them, but each state is going to have a varying standard in terms of their presumptions regarding those types of waivers. Another issue that may come up in the months to come is the public policy exception for liability waiver in the midst of a global pandemic. And some courts will not enforce a liability waiver if it violates public policy. It remains to be seen whether courts will implement that type of exception here. So with that, let me turn it back to Ruth for some additional personnel issues.
Thanks, Andy. So I'm going to briefly touch on some of the likely personnel issues that employers who are recalling employees to work may face and that we've seen have already started to come up. For example, some employees have expressed a general fear of contracting COVID and have advised their employers that they don't want to come back to work. And employers have asked us, is that allowed? Can they just say they don't want to come back to work? And the answer to that is that generally an employee would only be entitled to refuse to come to work if there is a danger in the workplace that can reasonably be expected to cause immediate or imminent danger of death or serious physical harm before OSHA can investigate. As a result, employees are generally not entitled to decline to come to work if the employer's request to return to work is in compliance with the government orders about reopening, and the employee's reason for declining is just a generalized fear of contracting the virus, as opposed to if there's a current widespread outbreak at the office or something, and then they might have a, a stronger leg to stand on. But, importantly, in addressing employee concerns about coming back to work, we really recommend that employees address them on a case-by-case basis and ensure that similarly situated employees are being treated consistently because, as Marcia will discuss, there are discrimination issues and disability issues that could come into play with respect to specific employee circumstances. Another issue that employees have been contending with involve how to handle employees who are over the age of 65 and thus at higher risk for developing more serious complications from COVID-19. From an employee relations standpoint and based on CDC recommendations, employers should try to accommodate these employees if they raise concerns regarding COVID-19. And that would involve things like allowing these employees to telework or to take an unpaid leave of absence. However, in preparing return-to-work plans, employers should not assume that employees who are over 65 do not want to come to work. So we would not recommend proactively asking only the employees who are over 65 years of age, hey, do you want to come to work? Because I think, that can get into issues of discrimination to the extent that these employees don't want to be treated differently. But if they have an issue and they, raise it with the employer should be ready to address it and should try. As Marcia mentioned, there also may be concerns employees raise regarding returning to work because of child care concerns. If they don't have a specific leave available under the FFCRA or another similar state statute, employers don't need to necessarily accommodate those concerns. From an employee relations standard, again, you may want to, but if it's essential for an employee to come to the office twice a week and they express they have child care concerns, you can require them to come in if you really need them to. Another concern that may be raised by employees involves the use of public transportation to get to work, and the CDC has actually addressed this issue and said that if feasible, employers may want to offer incentives to use other forms of transportation, allow employees to shift their hours so they can commute during less busy times of day, and obviously ask employees to wash their hands as soon as possible after a trip. Another issue is employees who refuse to wear a face mask for employers who require it. Again, absent a disability or an issue, a religious accommodation issue with respect to wearing the mask, employers can require employees to wear masks, especially given the current CDC guidance and the guidance from most local authorities. With that, I'm going to turn it over to Marcia.
Thank you, Ruth. So here we're going to talk about discrimination and retaliation. And I'll say one thing to start, which is many of us and many employers may be saying to themselves, give me a break. We're dealing with a pandemic. Don't we have to not worry about discrimination and retaliation? But the reality is that as people are as employees are feeling uncomfortable about the requirements that employers in the world are placing on them and are worried about their health and worried about their families, we can predict that we are going to see an upsurge rather than a decline in discrimination and retaliation cases and claims as people come back to the office and as the life that some people have gotten used to begins to change. So I'm going to reference back to the 5 W's and the various planning considerations that Ruth talked about earlier in this program, and her advice to document the reasons and to look at disparate impact when you look at your criteria for bringing people back to work. And that is very important in terms of reviewing the possibility of all kinds of discrimination claims or different impact. So age, Ruth mentioned, and I agree that you will not be telling your over 60 or over 65 employees that they shouldn't come to work because it's better for them. Rather, you'll be listening to what they want to do and acting based on that and your business needs. When we think about the ADA and state disability protections, these are likely to come up in terms of reasonable accommodations, looking back to things that have been mentioned previously about concerns about coming to work because of underlying conditions, concerns about wearing masks, and other issues. So those, as Ruth said, you will deal with on a case-by-case basis. Some employers, especially larger employers, are coming up with questionnaires that are targeted to the concerns that they will take into account, and that is a good way of documenting what your business concerns are. Direct threat, as Ruth mentioned, the only reason to not come to work is that an employee can say they're not coming to work is if there's an immediate threat of death or to their health. Again, people may request accommodations because of health or safety, or the employer may want to impose limitations because of health or safety. All of those are highly individualized determinations. And if an HR team suggests you can do things on a blanket basis, that's setting the company up for risk. I have on here perceived preferential treatment, which means perceived discrimination, and there's going to be a lot of employees looking at that around both the requirements and the opportunity to come back to work. We've heard some clients say that they have people clamoring to come back because those individuals perceive that they will be advantaged from a performance and advancement point of view by coming back to work and by saying they want to come back to work. And in other cases, as you heard, you have many people saying they want to continue to work remotely or to not work at all. And employers will be having a very confusing mix of direction and wishes from their employees. So it's all the more important to set up consistent standards that you document for whose requests you're going to grant, on what basis, and also to document how you've done that, why you've done that, and what are the general exceptions that you've come up with. I'll just say a word about pregnancy, which early on in the COVID crisis, it was thought that COVID didn't have an effect on pregnancy, but now it seems that it likely does. So for pregnant employees who doctors recommend they shouldn't be back in the workplace, that's a consideration to take seriously. So moving on to the next slide. Reasonable accommodations can include both modifications to safety equipment, but it doesn't necessarily have to include that. It can include additional leave, and it also can include discussions about exposure to particular coworkers and visitors. We talked about serious health conditions, and just a minute on retaliation. In the compliance world, there's the view that when a crisis occurs and businesses and employees are focused on other things, focus on compliance drops. Now, when we begin the return to office and there are a lot of concerns that people have, both employment-related and otherwise, we are expecting to see an uptick in whistleblower claims. There also is a sense among employees that they each have the obligation to speak up, and the Hinich versus Norwood Life Society case is a nursing home case in the Chicago area where an employee felt that the nursing home was being haphazard in training about masks and in usage of masks, and that was putting both the residents and the employees in danger. And she complained that she was treated badly because the organization thought that she was going to raise compliance complaints. That's just an example, a microcosm of what you can see coming up in a lot of different circumstances. finally, I'm going to mention a kind of unusual anti-retaliation ordinance that you'll see a link to in the back. In Chicago, there's a new anti-retaliation ordinance that says you can't retaliate against employees for taking off for various COVID-related reasons, including quarantine, childcare, et cetera. And in that case, retaliation seems to mean discipline for taking off work, regardless of what your rules are. So, and the damages are quite significant. There are treble damages, plus normal damages, plus apparently consequential damages, and attorney's fees. So that is something to watch out for in Chicago and various other locations. I turn it back to Andy.
So I'm going to talk briefly about wage and hour issues. They can come up in a variety of contexts here. The first being, it's important to update and refine your timekeeping policies. With so many employees working from home, if you haven't already done so, it's critical to think about how are we going to have them keep track and how are they going to report. So, you don't have key cards or badge swipes to monitor those kinds of things now. And to the extent you haven't already thought through those issues, consider whether you want to update them both in terms of how you communicate to employees, but also in your formal policies, because even as employers reopen, many will continue to work from home, and there's a greater risk of overtime liability and the like. The waiting time issue comes up in connection with temperature testing or health screening claims. In California, for example, in February of this year, the California Supreme Court concluded that Apple's mandatory bag checks of its employees at the end of the day was compensable time because it was hours worked. Apple controlled that process. They required it to occur, and it occurred on premises. And so it's certainly possible that employees, to the extent they're required to undergo temperature testing or wait in line to do so, or wait in line to provide health screening questionnaires at the employer's location, may bring individual or class or collective action claims for wage and hour issues, and that's certainly a risk for employers here. In California, too, reporting time pay is a potential claim. So if an employee comes to the workplace, fails a temperature test and is sent home, there's a regulatory requirement that the non-exempt employee get paid for part of that time, even though they didn't work. Finally, the business reimbursement statutes are critically important. In Illinois and California in particular, Illinois' law is relatively new, so there isn't a lot of case law on it, but it requires repayment for all necessary expenditures or losses incurred by the employee within the employee's scope of employment and directly related to the services that that employee performs for the employer. Well, in a work-from-home environment, many employees may be incurring expenses, from printer ink to paying for gas to run an errand for an employer to all sorts of other things for which they may submit claims for reimbursement, and an employer is obliged to pay them. The Illinois statute is important because it includes a requirement or a provision that an employee is not entitled to reimbursement if the employer has an established written expense reimbursement policy and the employee failed to comply with that policy. So it's important to have that policy in writing for those of you who have employees in Illinois. Briefly, a couple other issues that employers have considered are salary reduction measures and rolling furloughs. And rolling furloughs can be an effective way for an employee to actually earn more money than a pure salary cut. So if you have an employee who earns $1,000 a week for 4 weeks and you get a 25% cut, that employee would earn $3,000 for the month. But if they work 3 weeks of the month and are furloughed for the 4th week, they would still get their $1,000 for the first 3 weeks, for example, and in that 4th week, they may be eligible for unemployment compensation under state laws. So we've seen some employers raise those questions and issues to us as well, and there may be ways in which an employer can assist employees in that regard. But you need to be careful with exempt employees because if they do any work during a work week, they generally are entitled to be paid for that entire week. So it requires a lot of monitoring and control over what the exempt employees are doing. With that, let me turn it back to Ruth for a discussion of OSHA and workers' comp considerations. I also see we're running just a couple minutes late, and we appreciate your patience, and we'll share the CLE code shortly.
Thanks, Andy. So I'm going to briefly touch on OSHA and workers' comp considerations in connection with COVID-19. One of the areas of uncertainty throughout the pandemic has been whether employers are required to report cases of confirmed COVID-19 on their OSHA 300 forms. OSHA initially issued guidance in early April advising employers that COVID-19 cases are recordable under certain circumstances, but did not really provide much guidance on how employers are to determine whether the case is work-related. On May 19, 2020, OSHA issued revised enforcement guidance providing businesses with pretty specific instructions on, how to decide whether a COVID-19 case is work-related and therefore to report it. The basic idea is if there's a confirmed case of COVID-19 as defined by the CDC, and the case is work-related and involves death, the employee taking time off from work, or having to be put on restricted work or transferring to another job, the case is recorded. And the big question with COVID-19 is whether it's work-related, because the other two issues are sort of easier to deal with. And OSHA has basically advised employers that while they're not required to undertake extensive medical inquiries to determine whether an employee contracted COVID-19 at work, they do need to take certain steps, including asking the employee how the employee believes he or she contracted the virus, to discuss with the employee his or her work and out-of-work activities that may have led to the illness, while obviously keeping in mind employee privacy, so you can't get into too much detail, and reviewing the employee's work environment for potential COVID-19 exposure. And this point should really focus on whether there are any other instances of workers in the employee's work environment who have contracted COVID-19. And the guidance provides a number of examples where the illness is likely work-related. I'm not going to get into them in too much detail because we don't have time, but it's, mostly if there are several cases among employees in the same work site, or if the employee works, regularly with the public, then you can assume it's work-related. And if there's another explanation, or there's not really a huge exposure risk, then the employee, then you can find that it's not work-related. I'm going to briefly touch on workers' compensation liability. A number of jurisdictions have passed laws revising state standards for COVID-19 workers' compensation liability. I mean, just as with the reporting requirement, it's hard to establish that someone got COVID-19 at work and therefore it's workers' compensation, the employee is entitled to workers' compensation benefits, unless it's sort of more obvious. But for example, on May 6th, Governor Newsom in California signed an executive order creating a 60-day period in which there will be a rebuttable presumption that any COVID-19 related illness of an employee arose out of or in the course of their employment if the employee tested positive for or was diagnosed with COVID-19 within 14 days after a day in which the employee worked at the employer's place of employment. So it's good to keep that in mind and to keep track of those kinds of developments. And there's also the issue of immunity laws, which, Congress has discussed, but nothing has been passed yet on a national level. But a number of states have passed legislation providing some form of liability immunity to certain businesses. Many have sort of limited it to healthcare providers, such as in New York, but other states are working towards broader protections. For example, in late May, North Carolina passed new legislation pursuant to which essential businesses and emergency response entities are temporarily immune from civil liability to customers, employees, or users for claims unless the business was grossly negligent or reckless. Utah also passed a pretty general law. And so it's good to keep those in mind as an employer as well, and we're going to be monitoring those developments. With that, I'm going to pass it back to Marcia to discuss privacy issues.
Thanks, Ruth. So I'll be really quick here. Privacy comes into play in a lot of different areas here, and I think many employment lawyers have their best friend privacy expert on speed dial, so that's always a good idea. So when privacy comes into play, when you're talking about what's happened to coworkers from a health point of view, employees are going to want to know. They should know some information. At the same time, the ADA protects confidentiality, so there's a balance, and there are good guidelines and practices on that employers will want to implement when they go back to work. Have a policy, have a practice, write it down. Testing and screening for the new return to office, it has a lot of new privacy issues, and some of those have been covered. So when you have temperature or other screening for symptoms, make sure that you've considered the privacy aspect of obtaining that data. If you are not obtaining any data, you may have no privacy requirements. If you are, you may need consent forms. There are state statutes now controlling private information. I cited Illinois and California as examples, but many, many states now protect personal information. So when you're looking at ADA confidentiality, you'll also be looking at state protections. I'll spend 10 seconds on BIPA, which is the Illinois Biometric Information Protection Act. And in this context, that comes up primarily when you're using an app or another way of identifying people other than just by writing their name down. Andy mentioned reporting obligations to the public health agencies, and those exist in virtually every state, city, and county. Sometimes the primary reporting obligation is with the doctor, sometimes with the employer. Obviously, as employees return to the office, you'll have more information and need to bone up on those requirements. Ruth has addressed OSHA, and I'll just say one more thing, which is in the return to office, a lot of employers will be wanting to impose restrictions on out-of-work activity. A lot of employees will be asking for employers to do that. Most states protect lawful out-of-work activity, so when you put restrictions, which is entirely possible, but often they may need to take the form of a request, a recommendation, or consequences if the employee doesn't observe the restrictions. With that, I turn it back to Andy.
Thanks, Marcia. We have a link in a slide with the links to our various articles that we've published for US employers. This will be sent to all of you tomorrow as well, and we appreciate your patience and your participation today. So thank you very much for joining, and this will conclude our webinar today.